Right, welcome back. You're still watching Daybreak on this 23rd day of May 2022, a very important day as IEBC goes to meet with the presidential hopefuls in the pre-nominations meeting. Of course, they're expected to go through clearance or registration. This day is called towards the end of the week. That is from Sunday until the 6th of June. And again, there is that group of civil societies that came out yesterday and said that there are certain politicians who should not be allowed to run. We'll be looking at those slides shortly after now. But in the meantime, we also heard the Chief Justice speaking about what should happen to governors who have been impeached previously, whether they should run or not. I don't know what your thoughts are, Wakili Ogola, especially when you talk about, and you'll be seeing from the slides, leaders that have certain cases in court, some impeached, some barred from accessing the offices, and then they are now looking for public offices, whether the same offices or other offices.
I think the starting point would be to understand the distinction between the legal and moral conversation. Now, in terms of the legal aspects, Article 76, Subarticle 3 is express that if you have been removed from office for violation of the Constitution, you do not qualify to run for office. There is an express provision that locks Governor Sonko. It's an express provision that locks Governor Waitito. And therefore, to be able, I don't think IEBC is permitted to clear Governor Sonko. Governor Sonko would have to go to court, get an interpretation that permits him to run, because that law is express. If you have been impeached, you do not qualify to hold any public office. Now, the reality is, insofar as those governors and politicians who are facing corruption-related charges or some other offenses, the law has hamstrung IEBC and I think EACC and DPP. The presumption of innocence before someone is found to have violated the Constitution, unlike 76.3, talks about having been found to have been violated, the process of impeachment terminates with a finding that you violated the Constitution one way or another. Insofar as those who are facing charges but have not been impeached, the reality is they will be cleared and they will be on the ballot. But what I hear the civil society leaders raising as a genuine concern, in terms of moral and ethical fitness, would you say that such persons deserve to run? I don't want to be the one to make a decision on that, but a moral and ethical conversation would only lead to what we call social vetting. Social vetting now means let the candidates be known for who they are, let the voters decide. But voters are deciding at the ballot, which means they're going to be at the ballot. So the short answer is, if you have been impeached, you cannot lawfully be cleared to run. If you are facing corruption-related charges or any other offense in court, you will be cleared to run on the presumption of innocence.
And therefore, when an impeachment is passed, should they then consider putting it in writing that you're barred from accessing or holding either public office, or it doesn't matter?
The Constitution is expressed on that. Article 76, Subarticle 3. And if you are happy to read it, you could read it. It says, if you have been a state officer that has been removed from office for contravention of the Constitution shall not hold any other public or state office. So that is expressed in the law.
What did you say, Article?
76, Subarticle 3. Can you find it?
No, I can't find it.
You can't find 76?
There's 76, but there's no 76.
Okay. You will find, you just read on the conduct of state officers.
Okay.
It says, if you have been barred from office, if you have been removed from office by way of impeachment, such as Governor Sonko and Governor Waitito, you will be cleared to run on the presumption of innocence. And therefore, you cannot then be cleared to run for any office.
I think you're talking about 75.3.
75.3, yeah.
Let me just read it.
75.3, sorry.
A person who has been dismissed or otherwise removed from office for a contravention of the provisions specified in Clause 2 is disqualified from holding any state office, and Clause 2 is shall be subject to the applicable disciplinary procedure for the relevant office and may, in accordance with the disciplinary procedure referred to in paragraph A, be dismissed or otherwise removed from office. So
75, sorry, a correction for that. Article 75, sub-article 3 is express and unambiguous. You don't need any other communication to support. You don't need a judicial finding, Sam, to bar you from office. Yeah. For those who are facing prosecution, corruption-related cases, it is a moral and ethical conversation. You get the distinction? Whether someone who is facing graft-related charges ought to be allowed to govern or to be elected. That's what I call social vetting. Let the people decide. But I've also clarified, how are the people deciding? The people deciding presupposes that these people are at the ballot. So as sure as the law exists, IEBC will clear all candidates who are suspected of corruption or maybe are facing prosecution. But I think what I hear the civil society be saying, and they have a valid point, that you should know your candidate. And you should know and elect people who are as close as possible to the values the Constitution hopes to achieve. Okay. But those are now not, those are extra-legal conversations. Yes.
And Wakili, let me just call you Wakili, former commissioner here. Even as you read 75.3, if, say, Governor Mike Sonko goes to court, can they get stay orders or whatever? Can they get
some protection,
some orders to make IEBC clear them to run?
Yes, they may have the option to go to court, but I really don't think they would want to. Going to court is a tedious process, and especially you had the CJ making some pronunciation, which was not a judgment to that effect, almost agreeing with my colleague here. But the point, Sam, is in mature democracies in the Western world, once you are implicated in something, you see politicians resigning voluntarily, you know, because of what Stevie is saying, the moral aspect of it. But in our setting, mostly in Africa and Kenya particularly, people have no moral duty to, you know, to feel guilty of seeking political office because of corruption charges or impeachment. They say, I would rather die than resign. Now, where every politician implicated in corruption and facing impeachment is hanging on is in Article 99, 3, subclause 3, where it says a person is not disqualified unless all possibility of appeal or review of the relevant sentence or decision. Look at that word. Relevant sentence or decision has been exhausted. So all they are saying is that we have lodged appeal against my impeachment. I have lodged appeal against my impeachment. That decision made by the Senate, that's a decision. I have lodged an appeal, and that appeal is awaiting review. And therefore, our Constitution, Article 99.3, is clear. As long as I have not exhausted my, you know, that review of the decision, or I am clean. And therefore, you cannot fault IEBC for clearing the candidate because the law is clear. You don't need a court order to do that. You don't need. It's already here. Therefore, and remember, in the IEBC setup, the returning officer is the gazetted officer to clear you at your region. Right. You don't need a decision from the IEBC commissioners to clear a candidate because the returning officer has all the powers. He's the one gazetted. You are submitting yourself before the returning officer, whether in Mombasa, Nairobi, wherever. So this is where all those who have these issues are seeking refuge. You know, they say in our religious setup that seek refuge in Jesus, and all your sins are cleared, whether you committed them long time ago or now. As long as you came and you get to Jesus, Jesus has no problem. He clears you. This is where now, this is the altar. Everyone is running here. And remember, when President Kenyatta and Deputy President Ruto in 2013, there was that whole hullabaloo that they are not supposed to eligible. And so they set the precedent. They were facing ICC, which is more serious court than our local jurisdictions. And they were cleared. Therefore,
you cleared them.
Yes, we cleared them, and the country was happy for it. So you can't now subject these other candidates to a different set of laws just because they are facing criminal charges. They are alter.
And for you, even when you read 75.3 that talks about if you've been taken,
you know, if you interrogate 75 and you read it yourself, it goes around. In fact, read the last sentence. It is saying that, look, it's you who read it there.
Let me read it for you.
Read it again, yes.
It talks about... Just hold on, let me get it. Yeah, a person who has been dismissed or otherwise removed from office for a contravention of the provisions specified in Clause 2 is disqualified from holding any other state office. That is 3 itself.
Yeah, go on.
Then Clause 2 that they refer to, that the Constitution refers to, says that a person who contravenes Clause 1 shall be subject to the applicable disciplinary procedure for the relevant office, and may, in accordance with the disciplinary procedure referred in paragraph A, be dismissed or otherwise removed from office.
May. The word is may. You know, the law...
But you see, once you're removed, you're told that...
disqualified.
Is disqualified from holding any other any other state office.
Any other. Okay, but now all these laws must be read together. You know, the whole idea of our law in the Constitution and in the Elections Act and Political Parties Act must be read together so that there is harmonious interpretation of the same. Because you cannot then say that Article 75 is superior than Article 99.
99.3.
Yes, which then sets, and in fact, Article 99 sets out the qualification for you to run for office as governor or president or MP. It sets out, it even sets out disqualification. And then it provides thereafter at Clause 3 that even if you have all these issues of corruption, I'm not here to advocate for corruption, by the way, and you must understand that I am one of those people who really don't subscribe that we should allow these leaders to run. But I'm just reading the strict reading and interpretation of the law.
Okay.
Yeah.
I hear you. Wakili Ogola appears to disagree with you, but as you do that, would you have any knowledge on whether there's an existing challenge to the impeachment against maybe Governor Sonko or Governor Waititu?
I think they have filed...
there is, but you know...
They must have filed something in the Supreme Court.
Permit me to provide some clarification.
Okay.
And let the law speak for itself. The marginal note, or the subtitle of Article 99, read it for yourself. What does it say, Article 99? Qualifications?
And disqualification for election as a member of parliament.
Member of parliament. Have you seen governor there? No. Let's go sequentially. No.
Okay, can I help you there?
No. Just permit me to canvass this argument. Sam.
Go ahead.
We practice in these courts, yeah? And I can tell you that looking at the judgments we get from the High Court, the High Court has adopted what we call a purposive, holistic, teleological reading of the Constitution that captures and fulfills the aspiration of Kenyans and the intentions of the Constitution. On the same breath, the Constitution has discouraged formalistic and mechanistic reading of the law that permits manipulation of the intention of the Constitution. As sure as the law exists, in fact, Sam, please come and take my practicing certificate for 2022 and tear it to pieces if the courts ever clear Sonko to run for any office. Because looking at the jurisprudential orientation of that court, and this is captured in so many decisions, the High Court is very emphatic on this, that they will not read the Constitution in a manner that undermines its core commitments. Article 99 relates to election of members of parliament, and that is how MP John Waluke got a reprieve because his matter is pending appeal. Now the courts are also, their hands are tied because they have had an occasion to interpret what Article 99 means in the context of Chapter 6, where Article 75, Sub-Article 3 falls, yeah? And they said the law is express. It is the intention of the lawmaker that people who have preferred an appeal be allowed to continue enjoying the protection of the law. I think you can see the mischief in drafting. People who led us in drafting that Article 99 must have had the National Assembly in mind. They wanted to protect them, but they were not careful enough to protect governors. Article 75, Sub-Article 3, Sam, is express and unambiguous. And if any harmonization were to be done, looking at the arrangement of clauses, because now when you talk about tools of constitutional interpretation, you will look at which article ranks in priority to the other. Article 1, for instance, ranks in priority because it declares Kenya as the sovereign republic. So Article 1 is more important than Article 99. You can't have an election until you have a republic, right? Article 4 declares Kenya to be a multi-party democracy. It means it overrides even the possibility of having independent candidates, because Article 4 designates Kenya as a multi-party democracy, which means that the primary approach to organizing government is through political parties. So if there was ever a conversation on what should take precedent between political parties, I'm giving you a comparative reading of the law. If there was ever a conversation on what should take precedent between political parties and independent candidates, that conflict would be reconciled in favor of Article 4. I'm telling you that even if you look at the arrangement of statutes, the arrangement of articles in the Constitution and the chapters, it tells you that if there was a problem of harmonization, a purposive reading of the law would still arrive at a conclusion where people like Governor Sonko are locked from running, and Article 99 would be limited or circumscribed to those who are going for National Assembly.
Okay, I want us to listen to something.
I just want to take a take on his interpretation of Article 99. First of all, Wakili, all the articles of the Constitution must be read as equal and harmonized together. There is no giving priority to Article 1 just because it comes as number 1, that it is the superior article to 99. Anyway, that's aside. What my colleague needs to understand is that for you to qualify as a presidential candidate under Article 137, and you will read it in B, Article 137, 1B, is qualified to stand for election as a member of parliament. So the first qualification for a presidential candidate is to qualify as for a member of parliament. And that takes you to Article 99. So you can't just say Article 99 is strictly for member of parliament. So let me ask you, in your view, if you're to adopt the reading of Wakili Ogolla here,
the purposive reading,
hold on,
purposive, holistic, teleological reading, which captures the intention and the spirit of the Constitution.
What Wakili is doing,
just hold on,
is strictly being on the law.
If you're to embrace that, can somebody who is impeached, and sorry to use this example because you all have Governor
Sonko and
Governor Waititu. If they stood for election for the seat of the presidency, you're telling me they would be cleared?
I am saying that under Article 99, where everybody is seeking refuge, it clearly states that as long as that decision is subject of any court. And by the way, Sam, my reading also is that they don't need to go to rush to court to be cleared. No, it is the other way around. What happens is, if you feel that these candidates are not qualified as a spirited citizen, maybe you then run to court to have the IEBC stop from receiving their papers. But they don't have a duty. So I think there will be so many cases in the course of this week trying to bar these candidates from being cleared by the IEBC.
Let's listen to the leaders, the National Integrity Alliance, if I got that name correct, on what they said yesterday.
We have currently filed a petition in court seeking a legal interpretation on the minimum integrity threshold of candidates seeking elective and appointed positions in public service.
If you have been charged, then it then follows that you should be reclused from seeking public office, because you could be elected, and then the same argument will still hold in a court of law, that you'll be asked to stay away from your office. And we have seen how particular counties have suffered because of absentee leadership.
Okay, so let me try to take it forward. Assuming, Commissioner, that Mike Sonko is cleared, runs for governorship in Mombasa, wins that election, And we know that before he was impeached, he had been barred from accessing the office of the governor.
Yeah, yeah.
What would happen in this case in Mombasa?
He will simply say this is a new beginning. And by the way, I have heard that clip which is played by those ladies, that they're saying we are rushing to court. Because the duty to go to court is not on the candidate, because the candidate is covered in the Constitution, in my understanding. So what they are doing is trying to get an interpretation of the courts to stop all these leaders who have been impeached or facing corruption issues. So they are aware. It seems that they are aware that the law is on their side, so we need to seek some court order to stop them, to stop the IEBC. So I don't think if Governor Sonko is cleared to run for Mombasa, that's it. He becomes a new governor, and it's a new beginning with no restrictions. That court order was in respect to Nairobi, and all that appertains in Nairobi governorship then for him.
Justice Mubingogi, I think it was in...
No, Sam, just hold on. The clip you've played, yeah? We must not misquote them, because that clip is self-explanatory.
Right.
What the civil society leaders hope to achieve is to litigate on the moral and ethical requirements and to have a judicial pronouncement that matches with their position insofar as persons who are suspected to be corrupt or persons who are facing criminal prosecution to be barred from office. In short, they're trying to move the court to read Article 99 in a manner that locks out people who have been cited of corruption. Yeah? They're not trying to amend or maybe anchor Article 75.3. No. That petition that Wanjiru Gikoja is talking to and Sheila Masinde are talking to, the National Integrity Alliance, that alliance, yeah? What they're hoping to achieve is that how do they give how do they have this moral conversation on ethical and moral fitness have a basis in the law? Because, you know, that is what cleared President Uhuru Kenyatta and Deputy President in 2013. They were running on the basis of presumption of innocence, because the law said as long as you have not been convicted of an offense, you are presumed to be innocent. And now they want to overturn that kind of reading. Yeah? Right. But that is different. Let's not conflate or confuse Article 99 and Article 75.3. Article 75.3 talks about removal, and it's final. But anyway, Sam, let's finish that. Let's transition from that conversation in this manner. That provision is self-explanatory. IEBC, as I know it, is bound by that provision until IEBC makes a decision to clear Sonko, for instance. Only then can a public-spirited citizen rush to court.
Right.
We have to wait and see IEBC's decision. But if IEBC decides not to clear Governor Sonko, as they should, then IEBC shall have complied with an express provision of the law. Then it would be on Sonko to go to court and persuade the court that Article 75.3 notwithstanding.
Right.
I also need to benefit from the protection of the Constitution the same way MPs benefit. You get? It would be Sonko to read. I think, you know, for me, I'm a practitioner. I don't earn my money from politics. I earn my money in the corridors of justice. This country belongs to Kenyans. If you have a constitution that you want to devalue, you want to read down, you want to obliterate, completely even take it away, that's a decision we can't make on a panel like this. That is a decision Kenyans will make.
Sure.
It's their own country. But for me, what I know is that the judiciary, especially the High Court, in the series of judicial interpretation, they have a very fiercely aggressive posture when it comes to protecting the Constitution from what I called a mechanistic reading in a manner that permits it to water down its intention. Okay. They're very keen on propping up the Constitution. It's very unlikely that the judiciary will depart from that approach.
And Commissioner, yes. In 2019, I believe it was in 2019, Justice Mubingogi was deciding on a matter of Samburu Governor Lenol Kulal, and she said that Lenol Kulal is charged with basically enriching himself at the expense of the people of Samburu County who elected him and whom he is expected to serve. Public interest would demand that elected officials do not continue spearheading public matters with control to the same resources they are accused of embezzling. And this is some of the foundation that she depended on, and even other matters that of governors that have been charged in deciding that they be barred from accessing the office. So does that change when you switch your workstation? Or even, for instance, Governor Muthomi Njuki has also been barred from accessing his office. Does that change by winning a new term?
I think it will, because if we are going to a new election and you get elected elsewhere, if, for example, that happens to Sonko or to Kidero in Homa Bay, this judgment was specific to the governor in Samburu, you know. So if they win election elsewhere, I'm sure they can't be barred from accessing office because of the order.
But if Muthomi Njuki wins election in Tharaka Nithi, do those conditions change?
Well,
because of the election?
I think so, because it was the judgment was in relation to an office in 2019. And so you can't keep on transferring that. I'm just using very simple terms, not the legalistic. You know, Wakili is in court all the time and using words like purposive. Wananchi don't understand that, Wakili. Let's be simplistic here so that people who are listening to you don't get complicated
Are you saying this thing was simplified?
All of them. I mean, simplified language so that our viewers out there can understand. Now, when you say purposive, my friend, we are compounding issues. So, so let us try to guide the process in a manner that everyone can understand. Our constitution was not meant to be that complicated. In fact, it has been interpreted in Kiswahili so that others can get to understand.
Wakili, I want us to transition from this, but what is your answer? Do circumstances change?
Him is strictly on the reading of the letter
just hold on.
of the law.
Allow me to
because, fine, General Kulal has finished his 2 terms that is allowed by the Constitution, but Governor Muthomi Njuki is seeking a 2nd term. So do circumstances change because of an election?
Circumstances do not change, and this is why. Such judgments and rulings are what, again, at the risk of being relegated as a legalistic person, are orders in law, because this is technical, These are orders in rem. They bind everyone. The court is interpreting the Constitution and what its implications are on persons who hold public offices. If the principle, orders in rem, these are like guideline judgments, that affect everyone, that are everybody is supposed to harmonize, to reconcile their position with that, to match that fact. If the principle is, if you have been removed from office, then you're barred from holding any other state office. Does it then matter that you're holding it in Mombasa? Some. You know, the challenge that we'll have is this. There is what we call the paralysis of analysis. When you start splitting, there will be no end to splitting, and then you lose track of how far you have split. The thing is, Governor Sonko has been found unfit. But I have a lot of respect for Governor. I think he's a great mobilizer. And I think Nairobi still needs him if Polycarp Igathe were to win. If you're talking about politics, but I'm not here to talk politics. I'm here to supply the implication of the law on politics. The implication of the law is this. If you have been removed from office, you are disbarred from holding any office pursuant to Article 75, Sub-Article 3. Then it doesn't matter that you're holding that office in Nairobi, Mombasa, Embu, anywhere. It doesn't matter that office is no longer elective or appointive. You are disbarred totally. It doesn't even matter that now you have a new election. But if you find a problem with that, and I'm not saying that there's no problem with that, Sam. If you find a problem with that, then, you know, this is why I have a problem with our leaders on both sides of the political divide. There's an opportunity for Kenyans to go back to the ballot on a referendum, audit the Constitution and decide to whittle it down so that we make it as permissive as it can get, so that if you serve 1 term as an impeached governor, in another election, you can run. Remember, let me give you an example found in section 44, 45, 46 of the Elections Act. Read together with Article 4 of the Constitution, the clauses on recall, the right of recall. The Elections Act provided that if you recall an MP for violation of the Constitution, that MP can participate in the subsequent election.
Right.
Do you know what happened in court? Justice Chacha Mwita declared that provision as unconstitutional. So it means The judge was already harmonizing provisions of the Elections Act together with Article 75, Sub-Article 3. Because if you have been recalled for violating the Constitution, we don't need to wait for you to be impeached the way we impeach governors. The law provides for recalling MPs.
Right.
If you have been recalled, why should you participate in that election, do the same thing? So already that provision of Section 45, 46, 47 was declared unconstitutional, and the judge directed Parliament to amend that act within 12 months. They have not amended it to date because they want to continue benefiting from it. I mean, let Kenyans decide.
But no, it cannot be used if already there's an order.
So right now, we know what it means now. We don't have a framework for recalling an MP.
Sure.
But the judicial pronouncement there can provide significant insight to this conversation. And the way I see the development of the law through court, through judicial interpretation, Article 99 that allows, 93, may one day be read down. Reading down means you try to minimize the opportunity for people who have been convicted of offenses from benefiting from it.
Okay.
But until then, maybe that is what that petition seeks to achieve.
44.
Commissioner, let me bring it. Let's hold on.
Candidates.
let me bring it closer to you, because you are a lawyer, and in your profession, there are state officers called the judges.
Yeah.
So if a judge is removed from office, can they run for a state office?
Sam, you know what I want us to do is not to go into academic arguments here.
No. I mean, we're talking about someone who has been removed from another state office.
The short answer is no. They can't run.
Okay, think about it.
Let's think about it. But I don't want us to go into it.
They can't run.
That. I'm looking at what I'm told is the checklist of clearing the presidential aspirants, which will be happening starting Sunday, that is the 29th of May, and today there's that pre-nominations meeting, and one of those is that Wakili, I can hear you on mic. One of those requirements is that must not have been dismissed or removed from public office for contravening the provisions of Article 75, 76, 77, and 78 of the Constitution. Well, I haven't looked at the entire list, especially for the candidates from political parties, to see whether any of them has been affected by that. But also, what should we be expecting? Because, Commissioner, you were there in 2013, and you went through the clearance of presidential aspirants. Of course, there has been another election in 2017, and now this one. What has been your experience? On what changes do you expect this time round?
The pre-nomination conference by IEBC is a new one. We didn't have it during our time. And I think even 2017, it was not there. It's a good thing, though, because it's administrative. It's not in law. The pre-conference is not in law. In fact, a candidate can choose not to attend because it's just administrative. What IEBC is trying to do is trying to take the role of educating the candidates on what they need to comply with. They just are trying to tell the candidate what the law says. Because even I look at the requirements here, they have replicated the Article 137 almost verbatim. You must have, you must be a citizen of Kenya. That's what they are saying. What they have done is replicate and reproduce Article 137, and that's what they want to read to candidates. As I've said, that pre-conference is not in law. It's not in the Election Act. It's not in the Political Parties Act. It's not in the IEBC Act. But it's a good thing. I have said it's a good one, really, for just managing so that everybody knows their place. But I expect that a serious presidential candidate would have been having a team of lawyers to advise them on this. They don't need IEBC to tell them that they must have 2,000 registered voters to sign, to be presented. So, having said that, I think it is a good thing, and the IEBC is just trying to set a candidate. The 44, the 44 independent candidates?
There are 40.
40?
Yes.
That's a large number for our ballot papers. In fact, if we put all those people in that ballot paper, it will become a booklet. And it will bring a lot of confusion to voters. So you are looking at 40 candidates plus 2. You know, I think that whereas the registrar of political parties may have cleared. Because, you know, for a registrar of political parties, all you need to do is to show that you are not a member of a political party. You need to show the registrar that you have a symbol. If I say my symbol is this pen, the registrar has no issue with me, as long as nobody else has the pen as the symbol. So she clears you. The registrar has cleared you, so you are a candidate. Now, the big challenge, and this is where I speak to IEBC, is to look at these 40 candidates and sieve them, because they must produce the 2,000. I think our constitution has been very lenient to these people. Just 2,000 registered voters. I can walk to the street and get all these 2,000 within a week.
But this time round, IEBC says that you're required to have copies of IDs from those signatories.
Again, that's not in the law, because there is the issue of privacy or confidentiality of a voter. I'm not sure whether they will get the IDs. That is also administrative. And therefore, let's see whether all these candidates, I think what will impede or remove most of them is the fee required to be paid at the IEBC. Is it 1 million?
1 million.
I think 1 million.
Yeah.
Most of them are brick figures, guys. I don't think they will raise this 1 million.
So you think, of course, there are 40 independent aspirants for the presidential seat, 14 from political parties, including Kalonzo Musyoka, and 1 from a coalition political party. That would be Raila Odinga. So in total, 55
The largest ballot
aspirants.
paper in Africa was in DRC. I think they had almost 8 candidates.
How did they do that?
They had to print a booklet, you know.
And that also becomes difficult for
Very
Tali.
difficult.
We'll talk about that. But Mule Musau is now joining us via way of Zoom. Of course, on the side, you'll also be seeing some images of the statistics about this election. But Mule Musau, good morning. And we were hoping that you'd join us earlier. We're now near the tail end of the show. But all the same, what is your take, especially on the processes of clearance of candidates and that conversation that you are having on the position of aspirants who have some pending matters, while others have already been impeached? What would be your take?
Thank you very much, and sorry for not making it into the show. I ran into some problems, but let me quickly do this because I know you're just coming to a close. In terms of our position has been very clear in terms of those people or those aspirants who still have a lot of problems. We have argued that we have an entire chapter in the Constitution which talks about integrity and values in Chapter 10 of the Constitution. And therefore, anybody who wants to become a public servant in this country, or at least to be in public service, and because we hold that position, or you hold that position in trust, so that the public can be able to entrust you with particular responsibilities, then there must be a minimum threshold of the kind of leader that we want. And therefore, because this is spelled out in the Constitution, our position has been that where we have individuals who've been impeached for one process or the other, and I think the Chief Justice has already spoken to this, that already is a disqualification by itself. All the other matters pending which need to be addressed, we need to find a very clear position, and I think the civil society groups which yesterday called on clarification from the judiciary in terms of what then is a threshold. How do you describe, how do we discount those people who have what we'd call blemishes in terms of holding public office? So our position is that we need to have a list which is vetted by IEBC and which goes out to the public when it is very clear who can be able to hold public office and who cannot be able to. So that's my first position.
Okay, all right. And as you reflect, because we're getting into the very defining week, IEBC begins to clear candidates, and you're looking at the presidential election aspirants, a total of 55 of them, 40 being independent. For you, do you see as an advancement of Kenyans exercising their right to seek public office, or is it a symptom of the failure in our systems on how to vet, and also even from the political parties that are supposed to be vetting who should run or not?
I think in my view, first we need to agree that we are still a young nation, and a number of things are starting to come to the fore. I mean, we're starting to realize, for instance, that political party positions or even political office, not just for a select few. That means that most of us now are starting to work up to the reality that we can become MCAs, we can be able to become the members of parliament, and we can also be able to aspire to the highest seat. How long has it taken women for them to be able to really robustly start participating in political processes? So in my view, I think it is the expanded space which has invited the participation of very many people. Of course, in time, we'll be able to weed out pretenders from the ones who are very serious. But my take is that I think it's an open space. What we need to come up with is to just ensure that first, we don't disenfranchise anybody in the process of trying to say we want to have a leaner team. But second, that through the ballot, through the practice of electoral democracy, we can be able to finally be able to come up with the very serious people who may have a very serious agenda, or an agenda that can be able to address the issues in the country.
Mm-hmm. And then there's that comment that commissioner here, former commissioner, talks about the situation of requiring presidential candidates who are submitting 2,000 names from at least 24 counties. They must also have copies of their IDs. For you, do you think it's just a measure to make it more difficult for aspirants to be cleared, or is it something that is actually legal? Commissioner here feels that it's unconstitutional.
In my view, I think there must be a threshold to your desire. In terms of your desire to become the presidential candidate, we must see some element of support. You know, everybody can be able to aspire for that position. Every person in the country, of the over 47 million of us, can all be able to aspire. Of course, the ones who are qualified in terms of the majority age. Mm-hmm. But I think there is a need for for determination of where your support is coming from. If you say that you want to become the presidential candidate in this country, then it makes sense for you to be able to say, I have people around me. And we have been asked in these things, so very many times when you go to these offices, people ask, who is behind you? Mm-hmm. Who is supporting you? So I think it is the minimum requirement to allow people just to be able to say, these are the number of people in every county. I think I'm able to draw out at least 2,000 people who are able to support me. Mm-hmm. It's a minimum requirement, because you're still seeking the votes of over 22 million voters across the country. Mm-hmm. So it is good to give an indication that you can be able to get that. Of course, I will agree to the fact that we do not need to have unnecessary restrictions barring people from participating. But in my view, that would be just a minimum take of the requirements.
But do you agree that you need to have people producing their copies of IDs or passports?
The question of IDs, ELOG, we have had a number of run-ins with the issue of verification of signatures. Mm-hmm. And our biggest problem has been that we are not clear whether the person who is signing is the same person, or whether they have given their support mm-hmm. to a particular initiative. We had a problem with Okoa Kenya. Mm-hmm. We still had a problem even with the BBI initiative in terms of the collection of signatures, because people come and sign, and we know that people are mobilized in shopping centers, and one person just sits there and keeps signing the entire day. I think it does not make it easier when you have a copy of the ID, mm-hmm. But at least it allows.
Well, unfortunately, we have a challenge with Mule Musau's signal. As soon as he's able to get back, we'll continue that conversation. But Wakili here, so all these requirements, are they within the regulations, or what confidence does IEBC have to go ahead and implement this?
IEBC has the mandate to do all that it has, or it can, to ensure that compliance with the electoral laws, including compliance with nomination requirement, is achieved. And if part of that implementation of its mandate requires that candidates supply copies of IDs of their supporters, I think that would be a welcome move. So not everything that IEBC does will be questioned on the basis of what is the legislative or legal underpinning. Mm-hmm. The right question to ask would be, is it unconstitutional? Is it illegal? Because clearly, if it aids in verification that this maybe somebody has put my name and signature mm-hmm. on a that I don't even know about. Mm-hmm. So, but you know, it takes effort to steal my ID from my wallet and photocopy it and supply it. Yeah. Mm-hmm. So that is an accountability measure. But there's something more pressing, mm-hmm. which we have not attended to, relating to the number of candidates that we've seen being cleared for presidential mm-hmm. and other elective positions. There are practical and legal consequences for such a large number of candidates. The practical is IEBC will have to work extra time, extra hard, to be able to manage all this large number of candidates who are running for office. It may even need more money. You know, I think when I tracked last, there was still a deficit of 4 billion. Treasury is yet to release, and it's very disturbing that Treasury owes IEBC 4 billion. Those are figures that are publicly communicated by the Commission. Treasury has not released part of the IEBC election management budget, operations budget. And even when it was releasing the money, it was doing so in tranches. Instead of releasing the money and let IEBC organize itself. Now, with a large, Commissioner has said correctly, you're going to have a booklet for presidential election. What is the financial or budgetary implication? Did IEBC anticipate? I think now you need to get someone from IEBC to clarify when they were estimating the election operation budget, what did they have at the size of the ballot paper? Did they have a standard ballot paper that accommodate up to 10 candidates?
Right.
Now that we're going to have more than 40. Do we need to double that budget for printing, including security features? Because these are drivers, cost drivers. It can mean that the election may not go on until IEBC gets this money. So I think a roundtable needs to be done between IEBC and Treasury on the budgetary implication. But on the legal implication, the presidential election, the law says that IEBC has 7 days to declare results. Already we have a history of showing extreme impatience with the announcement of presidential results. Kenyans generally want results announced here and now.
Right.
Voting closes at 5 p.m. You want by midnight IEBC to have announced who the winner is. And yet the law gives IEBC 7 days. Now the question we must ask is this. Because you see, when it comes to voting, counting, tallying, result announcement, the polling station, collation, and then final announcement of the result, when you have so many numbers, so many names on the ballot, it increases the administrative time. Will IEBC declare results within 7 days as per the Constitution? Because obviously, if you have more than a certain number of candidates on the ballot, that can affect that timeline. So if IEBC is not able to, then they will need to go to court quickly, probably for a judicial opinion, yeah? But I can see a challenge even in terms of declaration of results, and Kenyans must be prepared to wait longer, probably up to the 7th day, to get to know the actual result.
Okay. And for you, Commissioner, what is the practical difficulty? Because usually the presidential ballot paper has been just a page. If you had to look at 2017 and 2013, in 2017 we had about 8 presidential presidential candidates. But a ballot for nearly 50 candidates may, like you said, may require to be a booklet or on a newspaper spread. So what is the practical implication of that when it comes to counting the ballots?
First, the practical implication on the voter, it brings confusion. Because the time the voter takes to tick the ballot, I mean, you are like studying the booklet first. You peruse the booklet to look at the candidate if you have not already made up your mind. So again, in terms of the IEBC in counting the votes, they will have to look at the booklet, decide how many votes. So it takes time, you know. And as Wakili said, we have 7 days. The thing is, if our technology was going to work right, because I've observed election in the developed world. I've been to Australia, to US. And in the US elections, once the election time is closed at 5, by midnight of the same day, the entire country results are out because everything is electronic, you know, and the results are declared and finished in 1 day.
Right.
But in our situation, first of all, the electronic transmission has had issues. From 2013, it collapsed. I was there. The transmission simply did not work. And in 2017, the same thing happened.
Was it made to collapse?
Don't drag me there. What I'm trying to say is that this time round, can we see how, because IEBC is running what we call virtual, is it VPN? Virtual private network, granted, I think, by the teleco players. Then can we strengthen this system? Because I remember personally looking at the transmission in 2013, And somewhere in the middle of the night, and we were very sure, we said, guys, looks like by before the morning, we are done with this thing. Then by midnight, the transmission simply hung. The same thing happened in 2017.
I have asked you a question.
I have asked you a question.
You told me that I should not drag you there. Mule Musawe is back, and we need to wind up this conversation. Let me quickly talk about the gender requirement. IEBC says that the party lists, that is for parliamentary seats, that Senate and constituency member of parliament, should be compliant with the 2/3 gender rule. What is the thinking of Election Observation Group in complying with this? Because a few weeks ago we had the commissioner of IEBC, that is Abdi Guliye, who told us that one of the options that exist for political parties is to field candidates in areas that they had not fielded, never mind about the strength of those parties in those regions. What should happen?
I think, in my view, the question about the 2/3, while there's an attempt, while it's a good attempt to be able to make the political parties ensure that there's compliance, and I think that needs to be firmed up, it is the bad manners that we have in our politics that needs to be reined in. Because what you've just said in terms of getting numbers or trying to fill in these slots from areas where the political parties know they're very weak, will not satisfy the requirement come August the 9th. So I think we need to farm. It's a start, because first there's a need to ensure that the political parties and all the other actors in an election are trying to ensure that there is a culture that addresses some of the concerns that we have. And one of the concerns in our terms of our elective and appointive positions is that women are not involved as much as we want. And that's the reason why we came up with a constitutional requirement. So for me, first, we have made it's a good move to try to ensure that parties become compliant, but we still need to fasten the entire enterprise around that, because the question is, are we then sure that Maraga's advice that we had an unconstitutional parliament is going to be redeemed come August the 9th? So there are still questions about whether we can be able to attain that. IEBC is trying on its part in terms of ensuring that the parties, become compliant. Maybe there are more things that we can be able to do in terms of even the legal framework that allows us to be able to ascertain, or at least be very clear. Steve is there. I don't know whether he's talked about the question of proportional representation, but one of the things that we may have to do at the end of the day to attain the question of 2/3 is to change the electoral system. If we continue having the kind of system that we have, what we can always be able to do is to make ask of political parties to behave themselves, ask of the voters to also behave, so that they can be able to choose even more women into positions of elections. But we will not be able to subscribe bad manners, really. We cannot legislate bad manners, in other words. So at the end of the day, we may need to come up with a system that ensures that we can be able to get that. And the only system in the world in elections which can be able to give you those guarantees is proportional representation.
Okay, all right. Thank you, Mule. I need us to wind up. And Wakili Ogola, so, I mean, it doesn't really help if you're to pick aspirants in areas that you had not considered, because they'll still be beaten at the election and they'll not make it to parliament. But how do we avoid a situation of a parliament that is unconstitutional, knowing too well, even if Justice Martha Koome says that this parliament should be dissolved, there'll be a contest in court, and that may never happen?
Now, Mula is right when he speaks the long-term solutions, which restructuring the electoral system. I did a consultancy on that, on what we need to do to make sure that we redesign the electoral system in a manner that produces proportional representation. But in the short term, which is here now, there is a judgment in Katiba Institute versus IEBC, petition number 19 of 2017, in which Justice Chacha Mwita directed political parties to comply with the requirement that the list of their candidates to the 290 constituencies in the National Assembly do comply with the 2/3 gender threshold. And a similar provision in relation to the 47 governors, 47 senators rather. Now, as it is, I am aware that all parties happily have complied except UDA. I think they are in the process of complying. In the National Assembly, we have 82 parties participating. all those parties have complied except UDA and ODM. In the Senate, all parties have complied except UDA. And I think they are working around the clock to ensure compliance. But whether compliance at a technical level will produce the numbers is an ongoing debate. More likely not, because you're going to populate your list with candidates from areas where they don't have support. The party has no support. After the election, the deficit will be real. Petition number 401 of 2017 and petition number 397 of 2017, I argued petition number 397 myself. FIDA is in Kenya. FIDA Kenya is in court. CRU is in court. Crown Trust is in court. Civil society leaders and organizations are in court challenging the composition of the National Assembly, this 12th Parliament. Sadly, this Parliament is ending its term without a judgment on that matter. I think we'll keep on litigating on the matter until such a time we restructure the electoral system. The last word is this. Concerning the level of compliance now with this political party declaration that we are seeing now, I think let us have some level of deference to IEBC. It's very important that we keep on saying this, Sam. No matter the different divergent views that we have, IEBC is the expert institution that manages election. And IEBC has said, and the courts have said, only the presidential election, the results may be relayed through the electronic result transmission. But election regulations also specifically provide that those are only provisional results. They will not be binding until the returning officers arrive at Bomas of Kenya. The idea behind electronic transmission of results is to provide some level of accountability or preservation of integrity. Results will not be declared on the basis of electronic transmission.
Right.
By law, and IEBC has already restated that, I would urge that we, as much as possible, let us be guided and be led by the Commission, who are paid to manage election.
That's true.
And we will have that conversation as soon as the process of clearing candidates is over, or these days it's called the registration of candidates is over. We'll talk about how the election infrastructure looks. Let's take a look at this feedback of what you've been saying to us. Okelo Mwalimu on Twitter, you're saying, as long as constitutionalism exists, any individual who has either been convicted or impeached must not be cleared to run for any public office. Leaving the role of rejecting such people to electorate would be foolhardy, as they are likely to bribe their way back to power. Omwando Vickery, Kenyans have the moral obligation to reject politicians facing active corruption cases in court. Waiting for the courts to convict individuals who don't meet the requirements of Chapter 6 is tantamount to shooting ourselves in the foot. Malela, you're saying state agencies have a constitutional responsibility to clear leaders to run for public office. We can't clear corrupt leaders and those with the integrity issues, then asking Kenyans to reject them at the ballot. Sindani, you're saying Letangule seems to be telling us that the law is self-defeatist. Sonko was impeached and blocked from accessing office because of integrity issues. Law is meant to streamline human affairs, but if it can't, why do we have it in the first place? All right, very important questions. Odongo Rolex, surely Kenyan politicians are not serious at all. How can an impeached governor courageously vie and campaign for public office again? We should be very serious with who we elect. Of course, it's been cleared by a political party. Leonard Masika, you're saying that but the fact that someone has been impeached, such a person should be barred from occupying any office in the country. Let's not make caricature of left and right when it comes to issues of law. I think this is correct time we let new and pure individuals occupy offices. You said pure? Abere Jacob, Kenyans are also worried on big list or booklet of aspirants like presidential candidates, constituency and ward aspirants, example in Embakasi South and Bobasi. Let them do the necessary and chop some via technicality like carry and help defaulting. Okay, all right. All of us have wishes, and of course the candidates or the aspirants have their constitutional right to present themselves for election. Of course, the mechanisms that exist, we hope that will be in a position to do their job fairly and within the law. My name is Sam Gituku. Thank you so much, Commissioner Letangule, Wakili Steve Ogola, and earlier on Mule Musau, who is the National Coordinator of ILOG. We do this again some other time. Bye for now.